Okay, on the record in the matter of the state of Michigan versus Reese Evans, 25-02611, appearance, please.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
And good morning, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Reese Evans, who's seated to my right.
Okay, Mr. Evans was scheduled for a prelim today on assault with intent to do great bodily harm and an aggravated assault. And my understanding is that we're ready to proceed.
That is correct, Your Honor. The people are ready.
Thank you.
Preliminary matters.
Your Honor, at least from the defense side, I would ask for sequestration of witnesses. It's my understanding it might be just a one witness exam, but I'm asking for sequestration just in case.
And I do have officers just in case they are not here in the room. I have no issue with sequestration.
Sequestration is granted.
Thank you, Your Honor. The people would call Simon Ajac.
Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes.
Okay, you can have a seat, please, sir. Okay, so there's a microphone in front of you. That is so that the court reporter behind you can hear all of the testimony that you give here in court, but it will not make your voice louder for us. So please keep your voice loud and clear, okay? Okay, try that again, okay?
Okay.
Thank you. Also, if there's an objection from either of the attorneys, you have to stop speaking so that I can give a ruling on that objection. And then I'll tell you if you're allowed to give us that answer. All of your responses must be verbal. You can't do head nods or head shakes or uhs because we cannot write that accurately into the record. If you forget, we'll just ask you if that's a yes or no, okay?
Okay.
State your first and last name and then spell both.
My name is Simon, Simon. Last name is Ajak.
You can proceed, counsel.
Thank you, Your Honor. Is that Mr. Ajac?
Yes.
Okay, thank you. Mr. Ajac, do you know the defendant, Reese Evans?
Yes.
How do you know him?
I know him through 2010. We bought a property. We give the contract to somebody who was doing the roofing. Mr. Rabin ended up to be one of the roofing guys working on the roof on my property. That was the first time that I know him. Second,
You said he was working on the roof?
he was one of the roofers.
Okay.
That was back in 2010?
2010. That was the beginning of knowing him.
Okay.
2024 was a property on Michigan Avenue, 1114. I bought that property. And the property was related to him. His aunt, the old lady, was the one who owned the property. So
Judge, I'm just going to object. It feels a little bit like we're just testifying in the narrative now. Like, I mean, he can say, I know him from a construction project in 2010, but reciting a 15-year history, I don't think it's necessary.
Objections granted.
Understood, Your Honor. If you can just answer my questions, we'll make sure to get everything. No problem. So you said that you had contact with him in 2024, and is that because you bought a property? How was he related to that property?
his aunt was the one who owned the property, but he passed.
You said his aunt?
Yeah, one of the relatives.
Okay.
But the property was taken away from them, and they were looking for somebody to buy the property.
And so you were the one that ultimately bought that property?
Yes, and it was through other agents.
Is Mr. Evans here in the courtroom right now?
Yes,
Could you please identify him by a piece of clothing that he's wearing?
he is on my left hand on the red shirt.
Thank you. Your Honor, may the record reflect that the witness has identified the defendant.
Any objection?
No objection for exam purposes, Judge.
Identification order.
Thank you, Your Honor. Mr. Ajac, did you have an incident with Mr. Evans on August 25th of last year?
Yes,
And where did that incident occur?
it occurred in front of my property at about 5:25 to 5:30 in the morning.
So that's, I just want to make it clear, is that at the 1114 West Ottawa Street?
All right, that is my property.
Excuse me?
Yes,
And that's in the city of Lansing,
yes,
Ingham County, state of Michigan?
yes.
Could you please explain what started this incident that early in the morning? Or I guess, what were you doing before this all happened?
I woke in the morning, start my work at 6 in the morning. So I got out. I want to go and start my car going to work. So the battery of my truck died. So when I start the car going to work. So what I did, I have an old car. In my car garage, I went and grabbed the car in order to jump the car.
Okay. So you were jump starting your car?
Correct.
Okay. Did you see Mr. Evans at some point while you were trying to start your car?
Yes, I saw him with another guy coming toward me. They live across the street at the shed.
I'm sorry, I don't have an objection. I just want to make sure I understood what they said. They say that there was two individuals that were coming out?
Yes.
Yeah,
him.
he said the defendant and another guy was coming out, and then I don't understand what he said after.
And I believe you said coming from the shed.
Yes.
Oh.
So could you explain this shed then to the court?
Okay. There is a property, 1115. That property is owned by somebody by Steve. The shed is behind that, and that is where Mr. Evans lives.
Okay.
And he was coming from that shed. I'm very sure he does take the trash out for that property. So he was coming out with another guy.
To take out the trash from the property?
Yeah, he was coming toward me,
Okay.
but I'm on the other side of the street and he is on the other side of the street.
Did he end up making contact with you on that day?
Yes, he attacked me.
So when you say attacked, could you explain to the court exactly what he did?
All right. So when I was jumping, he began, to tell me some of the things that I failed to understand. Was telling me it's not a jumpstart. He began to cuss me out, and I did not respond to anything about that. He came closer, and I said, "Man, I gotta go to work." Immediately, that is when he began, to slam, hit me on the face against my own car. Then he threw me down. I managed to overcome him, his body up him, and they put me down. He was choking me
Okay.
that particular day, and his body was recording.
Okay. So I want to take it back for a second. You said that he was beating you on the face. How was he doing that?
All right. Like where you are standing, get this. All right. I was standing. Get this, and this is my car. So I was against the car. All right. And he punched me in the face, put me against the car, overpowered me. Then I managed, he was the one laying down before me. Then his body came. Both of them flipped me down. He jumped on my chest. He was the one choking me, and the other guy was doing the recording.
Okay, so you said that he was choking you.
Correct.
How was he choking you?
So I was laying on my bed. He was sitting on my chest, put his arm on my leg, and one of my arms, he was trying to pin both arms, squeeze them, but he would not manage. One of my arms was still out. So, and then when they were doing that action, it was a minute, I yelled, but there was no voice coming out. My nose, my mouth, everything was coming out. His body, and I was blank, one blank. could not know anything. His body said he is dead. He's dead. That is what his body said. All right. And somehow there was a car coming, or maybe there was a sound. Then he went, got out. Then the lamp was still down. Minute. After that, could be a minute. Got up. Came, sit in my property. Called the cop. Cop came. Both of them, two guys came. I was taken to hospital, but I told the story, but I could not comment.
Again, Judge, I'm sorry.
This is a narrative.
Yeah.
Understood. Sorry, we gotta ask questions. You can't give too long of an answer. So I want to go back then. You said that he put his hand on your throat.
Right.
Did he apply pressure?
Yeah, he applied.
And you said that you were unable to speak.
Correct.
Did you have trouble? Did he impede your ability to breathe?
Yes, he knocked my ability, but I was trying to yell so that somebody can hear me for help, and nobody.
So it was difficult for you to breathe while he was squeezing?
Correct. And even to raise.
And you had said that you had ultimately called the police. Was the defendant still present after you had called the
No,
police?
they left. They left. They left me on the ground.
Did you see Mr. Evans later that day?
On that day, yes, I did. I did see him at about 3 after I came out from hospital.
So you ended up going to the hospital?
I was on my knees.
I want to go back real quick to when he was grabbing your throat. How long did he impact your ability to breathe, if you can remember?
It could have been, I could not say it about the minute, but the action took a minute, it took time.
So it was for an extended period of time.
All right.
When you saw the defendant later that day, did you call the police again?
Yes, I called the police.
And did the police arrive?
The police did not arrive on time, but eventually they came at a later date.
Understood. What kind of injuries did you have as a result of what happened?
My knees were skin out, my neck, my chest, and so much everything on my mouth, my neck. And the police actually took some pictures. That particular.
Perfect. Nothing additional. Thank you.
Cross-examination.
Mr. Ajac, it's Ajac, is that right? Okay. I just have some simple questions for you. You indicated that you knew Mr. Evans prior to this day, is that right?
Yeah.
All right. And you said you knew him about 15 years?
Yes.
Okay. And had the two of you previously had any trouble with each other?
Objection, Your Honor. Relevance.
Do you want to respond?
I do, Judge. I think it goes directly to his motive and state of mind with regards to his testimony today. I think if there's a history of violence or animosity between the two, I think that's directly relevant.
I'll allow it. Objection to overruled.
Had the two of you ever exchanged difficult words or been in fights before?
We never fight before, but there was one incident that I'm aware of, and it was right after I bought the property.
Okay, well, look, let me just ask this. I'm not asking you to go into detail about
All right.
all of it, right? I'm just asking you. So, is it fair to say that prior to this incident, you guys did not like each other?
On my end, no. On my end.
Okay. No, you didn't like him?
No, on my end, I don't have a problem with him. That's a person.
Okay. How often did you lived across the street, is that right?
Correct.
How often did you see him? Did you see him every day?
Well, I walk every time, and when I see him, I can see him cutting the grass across the street.
Okay. But did you guys
No, we don't have that. We
Okay.
don't have the conversation of talking to each other every single day. No.
Okay. So on this particular day, it's somewhere around, I know you don't know an exact time, but it's somewhere around 5:30 in the morning. Is that right?
Yes, because I'm going to work. Yep.
Okay. And so you saw him coming out of the shed? Is that what your testimony was?
Yes, because yes, the direct driveway, you can see the direct driveway whereby that is the door right there, and if I see you coming from that door, I can see you.
Okay. And you indicated he was with another person at that time.
Correct.
Do you know who the other person is?
I don't.
Had you ever seen him before? The other person, that is?
Based on what I was told,
Well, all right, let me stop you. I don't want you to tell me anything about what you were told from anybody else. I'm just asking you personally, had you ever seen this other person before?
yes, I saw him, but do I recognize him? I mean, I know.
Okay.
Because
You don't know the other person's name, is that right?
I don't know his name.
All right. You saw the other person, I think you said you saw the other person recording something on their phone.
Yes, both of them were he was doing the action, the other guy was standing,
Was just standing there.
just was standing.
Did the other guy ever participate in, like, did he ever strike you or knock you down, kick you, punch you, push you, anything like that?
He helped, yeah.
The other guy helped?
Yeah, he did help him.
Okay. And you said that you were originally behind, or not behind, but you were in front of the car doing a jump start on the car. Is that right?
Yes, I had two cars.
Two cars. Okay.
One I'm jumping, one I'm using the car. to jump
Right.
down.
Sure. Did you actually see them walking the entire way towards you, or were you behind the car and so you couldn't see them until they were right there?
Yes, I see him. The other guy was in a distance, but he was the one coming.
He is in my client was the one coming.
Yeah, he was
Okay.
the one coming.
And he walked up to you, and there was a period of conversation at first?
Yeah, he was talking to me and said it is not a battery. Was kind of like it is not a battery, it's a jumpstart, and it was passing out. And I did not say anything.
Okay. So at first you thought, was your personal impression that he was there to be helpful or what?
I did not even thought about whether he is gonna harm me because I never have any problem with him before. So I have no intention that he is gonna do harm to me or trying to kill me.
Okay. Just to be clear, I'm not asking you what was said, okay?
Okay.
But were you both talking back and forth to each other? Was there a back and forth, or were you staying silent while he was talking to you?
He was talking to me, and I was not talking back to him, but I was concentrating because I gotta go to work and I gotta jump my car.
Okay. And your testimony is that just as he's talking to you, he just out of the blue punched you.
I ignored him.
You ignored him, and so he just punched you.
Correct.
All right. And did he punch you in the side of your head or directly from the front? What?
Oh, on the side.
On the side of your head.
Right.
Your right side or your left side?
On my right.
On your right hand side.
On right.
All right. And he was on the right hand side of you at that time?
No, he was not on my right hand side.
Okay.
So if I can demonstrate it, this is the car I'm jumping on my left. This is the car that I'm using.
Okay. So you're in between the two cars.
And I'm in between the two cars. It's
Okay.
actually the car that I'm using.
Sure.
And he was coming toward that direction.
So
he was swinging.
Yeah, but was he, when you're saying you got punched,
Right.
was he behind you or on the side of you?
He was on side of me.
On the side of you?
On side of me.
On your right side?
On my right side.
And did you see whether he punched you with his left hand or right hand? If you don't know, that's okay too.
So I think it was a right hand
Okay.
because he's swinging.
Okay.
And that is when I realized, okay, now something is.
Where was the other guy at this point?
The other guy was just still standing. He did not do any action. The action when he came in is when he threw me down and I managed him. He was the one going down first.
I'm sorry, you said when he threw you down and you what him?
He put me against the car.
Uh,
It's two of us now. All right. Put me against the car. There is no other way. So we are wrestling right now. Okay. So instead of me going down, I managed. He was the one going down. His body came down. He helped him. They flip me down. And then he jumped on my chest.
okay.
And then the other guy stand up and record him.
All right. Let me make sure I understand what you're saying. All right. I don't want to put words in your mouth. I just want to clarify. All right. So you're saying that the two of you and my client
Correct.
started essentially wrestling. You're up against the car
Correct.
and you started to throw him to the ground.
Correct.
And then, correct, right? Is that what you said?
Yes.
All right. And then you were throwing him to the ground. And then once that happened, once you got on the ground, the other guy, not my client, this other third person that was there, essentially flipped you over so that you were on the bottom?
Yes.
Okay.
Yes, yes, yes.
And then once you were on the bottom, are you saying that my client was on top of you?
Correct.
And it's that point where you're saying your testimony is that he choked you.
Yes.
And he choked you with his hand?
What's he saying?
Where were your arms at this point?
One arm he managed to lock it down,
Uh-huh.
and one arm he wanted to lock it down, but he did not manage.
Okay.
So my right arm, he did not manage.
Okay.
And I'm very sure that is what saved me.
Okay. And he choked you
Yeah.
with his left or right hand?
It's trying to apply both hands.
He was trying to apply both hands.
Correct.
How is he applying both hands if he's locking your right hand down?
So he's trying to bring my hand down here, and he's locking this one down and lock it down,
Uh-huh.
ugly. And when he's trying to bring this one hand here, he's trying to grab me in a minute, and then I went back and pulled his arm out. So it's one arm versus two arms against him. So he got two arms,
Yeah.
and it's one arm.
And you said that he put his hand on your throat and squeezed, right?
Right.
And do you remember giving a statement to the police?
Yes.
And you told the police that he strangled you for 10 minutes and you lost consciousness. Remember that?
Correct.
You still agree that you were being strangled for 10 full minutes? I have no further questions.
Any redirect?
No, Your Honor.
Thank you. You may be excused, sir. Any other witnesses?
No, Your Honor, the people were list.
Any other witnesses?
No, Your Honor, thank you.
Argument.
Yes, Your Honor. The defendant in this case has been charged with one count of assault with intent to do great bodily harm, less than murder or by strangulation, and count 2 of aggravated assault. Obviously, the aggravated assault is a misdemeanor, so I would ask that follow the felony, and as we are only here for the felony charges at the preliminary examination. The elements for assault by strangulation can be found in the Michigan Criminal Jury Instruction 17.35. And there were 3 elements for that charge. The first is that the defendant committed a battery on Simon Ajac, a battery being a forceful, violent, or offensive touching of another person or something closely connected to that person. You heard from Mr. Ajac that on August 25 of 2025, at his property that was on West Ottawa Street in the city of Lansing, Ingham County, state of Michigan, while he was trying to jumpstart his car, the defendant and an unknown second person showed up, punched him, took him to the ground, got on top of his chest, and then started strangling him with one hand, as he referred to as choking. This is clearly a forceful, violent, and offensive touching. Number 2, the touching must have been intended by the defendant. That is not accidental, and it must have been against Mr. Ajac's will. It does not matter whether the touching caused an injury. As you heard for Mr. Ajac. Mr. Ajac was just trying to jumpstart his car. He wasn't trying to have any trouble and was ignoring the defendant while he was making all of his statements. However, what ended up happening is the defendant got upset. The defendant punched Mr. Ajac and once again brought him to the ground, got on his chest, tried to lock his hands down, and ultimately ended up choking him and putting his hand on his throat and applying pressure. It's clear, Your Honor, that this was intended by the defendant and it was against Mr. Ajac's will. Element 3 is that the battery is committed by strangulation or suffocation. Strangulation or suffocation means intentional impeding normal circulation of the blood or breathing by applying pressure to the throat or neck or by blocking the nose and mouth. And you heard from Mr. Ajac that while the defendant was choking him, he described that choking as putting his hand on his neck and applying pressure, so much so that he was unable to speak. He was having difficulty breathing, Your Honor. It shows that there was a clear impeding of the defendant's, of Mr. Ajac's breathing by the defendant. So we have met all the elements and we ask that you bind over. Thank you.
Thank you, Your Honor. First of all, I'll just say I recognize that probable cause is a low standard. I recognize that I recognize the elements of the offense. I do think there are some significant holes in the story. For example, I find it, quite frankly, highly incredible that he was strangled, actually strangled for 10 minutes. I've personally handled homicides in which the person was strangled for way less. The person died from strangulation way less than 10 minutes. That seems highly unlikely to me that assault occurred, that a strangulation occurred, that he lost consciousness and was strangled for 10 full minutes. But nonetheless, I recognize it's a probable cause standard. I would submit to the court that this is an aggravated assault. At best, I would ask that the court dismiss for lack of probable cause with regards to the.
Okay, for your benefit, Mr. Evans, this was a preliminary examination. So the burden is on the prosecutor to show probable cause that the felony that you're being charged with actually was committed, just to a probable cause standard. They also have to show probable cause that it was you who allegedly committed the felony. They don't have to prove each element beyond a reasonable doubt. And any issues that relates to a question of fact that comes out of the evidence, that's something that has to be resolved over at a trial. And so we have testimony today from one witness, that being a Simon Ajac. He testified that on or about August 25th, 2025 at the area at or near 1114 West Ottawa in Lansing, Michigan, making venue in this court appropriate, that he was outside jumping his vehicle when he saw the person that he previously knew or knows to be the defendant in this matter with Reese Evans coming from the shed at 115, which he says is owned by someone else, and that the defendant was with someone else, and that the defendant approached the victim, slammed him by the face or beat his face into the vehicle is what it sounds like he did, that there was some kind of tussle that ensued after that, that resulted in them being on the ground. It sounds like through cross-examination, the victim was able to push or pull the defendant onto the ground, but then the friend that was there did help get the defendant on top of the victim, and the victim testified that he was strangled or choked is the word that he used for approximately 10 minutes. The prosecution has already gone over the elements of assault by strangulation. And again, the defendant allegedly would have committed a battery upon Mr. Simon Ajac, battery being a forceful, violent, or offensive touching of another or something closely connected to another. I think the testimony is clear to a probable cause standard that there was some violent, forceful, or offensive touching that took place at the hands of the defendant. Second, that the touching must have been intended by the defendant, and that is not accidental, and it must have been against Mr. Ajac's will. It doesn't matter if the touching caused an injury. I think based on the testimony of Mr. Ajac, that we have met the burden on that element. However, the third, the battery was committed by strangulation or suffocation. Strangulation or suffocation means intentionally impeding normal circulation of blood flow or breathing by applying pressure or on the throat or neck by blocking the nose or mouth. The incident that was described by the alleged victim again was that the defendant had him pinned down and at some point had his at least one hand around the victim's neck. The victim did indicate that he believed he had been choked for about 10 minutes. In defense is arguing, obviously, that it's hard to believe that someone can be choked in what we know is actually strangulation for 10 minutes. But it could be that maybe the victim, maybe it felt like 10 minutes. He testified it took the police a long time or to get there. Maybe that's what it felt like. Maybe that's his perception. Maybe he's completely wrong. I don't find, although I find it hard to believe too, I don't know that that discredits the other portions of his testimony, which is that he was minding his business, working on a vehicle when he was approached and attacked. I also think there are some holes there because, not to say it's not likely that someone can attack you unprovoked, but for someone who you've obviously known for, it sounds like a period of at least 10 years, that they've never had this type of interaction, and then all of a sudden you're outside, he comes outside with someone else and attacks you, something's missing, I would believe, as well. What that something is, I don't know, or whether or not that something was something that would make me feel like with the story that was told to me today lacked credibility. I don't believe that. I don't believe that. I don't know that there's a lot that could have happened that could have warranted or dismissed an assault by strangulation. And the other concern that the court has is, although maybe it was 10 minutes, it could have been a long period of time where pressure was applied, but not enough pressure that would have caused him to lose life and or consciousness for 10 minutes. I think he did testify that there was a portion of the strangulation where he was attempting to scream for help, and that because of the pressure on his throat, he was unable to really do that. So maybe it wasn't as much pressure for the 10 minutes as maybe some of the other portions. That's something that could be fleshed out further if this matter goes to trial. I think there is sufficient probable cause, though, based on the testimony, to bind over count 1, and count 2 will accompany count 1 to the circuit court. Bind over date being February 25th. To be the date the circuit court receives the file from the district court. Not a court date for you, okay, Mr. Evans? Your next court date will be a pre-trial. Your attorney will be made aware of that date. Do you have any questions today?
Secondly, Mr. Palmer would advise that he was.
I don't know anything about you getting a new attorney or a new appointment. The public defender's office appointed Mr. Palmer, and if they decide they're gonna remove Mr. Palmer and put someone else, that's their business. The court doesn't have any involvement in that. He's the one who's been assigned to handle your case. Now, if you're requesting for a new attorney, and you want to hire your own attorney, then you need to get your money together and or find you another attorney. But you don't get to decide which public defender represents you. Do you understand that?
Yeah, of course, I'm just saying this is what he just.
Yeah.
Okay, I'm not sure that if that's the case, again, the court would have no knowledge and or input on which public defender gets assigned to your case. And so at this time, Mr. Palmer is the one who's been assigned. If they're going to switch that, that's up to the public defender's office. The court doesn't have any involvement in that.
Just to be clear, Judge, I did advise him that it is not anything that has to do with Mr. Evans. It is the fact that I have accepted a new position outside of the public defender's office. And so I'm leaving. There was at one time a discussion that Mr. Evans may be assigned new counsel prior to today's date so that that individual could be present to conduct the preliminary examination.
Okay.
For reasons I don't understand, that didn't happen. But I did advise Mr. Evans that I will not be his counsel after.
Got it. So you're leaving the public defender's office.
I am,
Got
yes,
it. Okay, well, congratulations to you.
Thank you.
And so for those reasons, obviously, you would have to get a new attorney because he won't be there to represent you. again, the court has no input of who that attorney is going to be. It'll be someone assigned by the chief public defender. Okay,
Can I address the court?
you can.
I would like to, first of all, I would like a copy of the forensics report. that I
Did
had.
you get did your attorney
I can give it.
got a copy of the forensic report and can get you a copy?
10th of December, Mr. Palmer had called me at approximately 3:30 on that day and explained to me that I would be detained because I missed the forensics examination, which I had no knowledge of. It gave me no information of that date. I was in constant company with pre-trial and was on tether, so there was no way that I could have been recognized. That date been recognized for forensics. So with that being stated, man, the other day, went to court on was that the 30th or something. I had just woke up, had no pre-knowledge of that I was even going to court. Like 10 minutes, they're like, Evans, you're going to court. I'm like, well, I had no knowledge of it was a court date scheduled for me. So, with that, man, I was a little groggy, uncomprehensive, as you might say, and this is how we ended up getting in 90 days. With that being said, man, I would like to know if you would try to at least give me some credit for that the days that I've already served.
You got found with contempt because of your disruptive behavior, not because you were groggy.
Understandable, man, but I'm just letting you know that my due process of rights has to be a certain amount of time before you to be acknowledged that you go to court. I had no knowledge.
Not for direct contempt. You were disrespectful and caused a complete disruption to me in court. Excuse me?
There was no precedent.
So now you get to determine contempt in my court. Okay. The contempt will stand. It's 93 days in Lincoln County Jail.
Well, what about what he has done, like as far as like me not having understanding?
Well, who has done?
What he did,
Who is
as
he?
far as
Your attorney?
Mr. Palmer. I stated that on the 10th. He called me and said that I missed a court date on the first.
He didn't do anything. So you're trying to blame it on him that you missed the
Well, I didn't have any knowledge of my comments to him.
Okay, so there was more than two things going on here. There was also a court date scheduled here for December 11th that you didn't appear.
No, I did. I was here. Yeah, when I got here, you weren't here. Mr. Palmer was not here.
That, just to be clear,
right here, this guy was here, and there was a black lady over there that was there.
Judge, just to be clear on that date, he did appear eventually. By my notes, he appeared a couple of hours afterwards. I think he had transportation issues.
And he was remanded for failure to appear to
I was stuck in the snow. But what I'm saying, what I'm asking you, that what is the deal with him not giving me? I didn't even have any knowledge that I had a competency hearing date, and I was remanded on the next day that I went to court. You see what I'm saying? So, like, I shouldn't even been in jail. I should just now be going to jail. But like there's like 60 or 70 days of my life that we're unaccounted for, and he's responsible.
He's responsible for 60 days of your life.
He didn't.
Man, sir, see, this is how you got here in the first place. This is how we got here in the first place. Did you give me an opportunity to finish my sentence before you cut me off to yell over me?
Well, that's what I was.
No, I'm asking you a question. What was my question I was about to ask you?
You didn't finish it.
Why? Because you cut me off.
Well, man, you cut me off too.
No, I didn't. And if I did, I get to cut you off at a portion that I need clarity for. I am the one running the court, not you.
I'm saying.
So when I cut you off, it's because at this very point, I need some clarification. So you have to stop to allow me to get clarification right there. Do you understand that? So you're saying that you did not know that you were supposed to have a competency evaluation, and that Mr. Palmer was responsible for letting you know that?
Yes, he was.
It's fine.
Judge, I think that's actually true. I want to be. I'm an officer of the court, and I think I absolutely have an obligation to be 100% truthful with the court. So I'm not going to try to hide anything here. I was not aware, and I've been looking into this as to why, but I did not see the competency or the order for his appointment until after the fact. I have some suspicions on why that happened. I have some suspicions about why that happened, and I'm just going to say that regardless of why I think it happened, it is ultimately my responsibility. I don't want to pass the buck. I don't want to try to make the court think I'm passing the buck to anyone else. I will fall on the sword and take responsibility for that. What I will say is that, and so I think to some extent, Mr. Evans is correct in what he's saying. And I don't want him
That
to
he was
be,
remanded, but it was not his error. It was he did not have knowledge.
I think that's true, Judge. And one of the things I just want to remind, to at least to my recollection of what happened, I started to address this very issue at our last court hearing. And then Mr. Evans was also talking, I'll put it that way, while I was trying to make the record, and the court found him in contempt before I could really get into that issue.
They find him in contempt for talking.
Or for speaking over you and interrupting the court.
No, he berated the court.
Right. I'm not trying to.
And he thinks it's funny.
I understand, Judge.
He said that he thinks it's funny. Listen,
Well,
if there's,
this is fraud in court, so.
Excuse me?
This is fraud in court. So what?
I don't know what you're saying.
You don't know. what
It's
fraud in court
I didn't
is?
hear what you said. I don't know what
You
you're
know
saying.
Fraud of the court is?
Fraud. I didn't know what you were saying. I wanted you to repeat it. What's fraud on the court?
Fraud of the court.
It's not fraud of the court. The court has there was the responsibility of your attorney
Which is what, my
to
process
notify
is?
you, this is what this says, that you were scheduled for an appointment with forensics, which the court ordered you to undergo some forensics. I don't know what the breakdown between you or your attorney was, because that's nothing to do with me. That's to do with you and your attorney. If there was a breakdown in the communication where there was your attorney didn't get the notice, or your attorney did get the notice and didn't get it to you, that's between you all. Before he could address that, which was last week, or a week ago, a little bit over that. Before he could address that, you became disruptive and we could not carry on a hearing. So I had to remand you because I couldn't get you to be quiet over there.
That's not true, man.
It's not, this is not up for debate. This is recorded in open court.
Yeah, but
It was not, it's not, you can feel free to FOIA and or subpoena a copy of the record if you would like to.
Yeah,
The court made its ruling, then the court stands by the ruling.
So what is it?
Regardless of whether or not there was an error made by your attorney, does not give you grounds to come into the courtroom and be disruptive.
He's violating my rights.
And then I didn't violate your rights. You came in here today and tried to say the reason why you were disruptive was because you were groggy. Now it's because your rights were violated.
Ma'am, you misinterpreted.
You can be
what I'm saying.
excused. You can be excused. I can carry on the remainder of the hearing without you. You're all set. You're all set. You're all set. Yep. You can get another 93 days. All set. Yeah, another 93 days. He was not found in contempt because he was talking. It's because he's disgustingly disrespectful.
Your Honor, I'd like to go a step further. I was there for that hearing.
Thank you.
Your Honor was attempting to figure things out with the forensic review process with Mr. Palmer. And you turned at one point and said, I'm trying to figure this out for you, something along those lines. And that's when you were yelled at by the defendant over Zoom. So I'd just like to put that on the record as well, that you and Mr. Palmer were trying to resolve the issue when you were interrupted.
No, well, it's consistent with the behavior that we've seen of Mr. Evans throughout this matter. And so that's neither here nor there. It's unfortunate that he was not the person who was at fault, it sounds like, for missing the forensic, but that does not give him grounds to come in and disrespect this court. And he will not get credit because of your error for coming in here, A, calling me out of my name, B, disrupting the process. So that's that. And he's getting an additional 93 days for contempt of court today that will be served consecutive to the one he's serving now. Any additional matters for the record?
Not from the people, Your Honor. Thank you.
Your Honor, thank you.
Thank you.